Hey, it's Amy Pittman, and I want to talk about what happens when a client of ours passes away. So if that client is a married person and they did a joint plan, we still want to talk to the surviving spouse. I don't need to talk to the spouse the day the person dies or even a week later, but we need to be informed that the client passes, and then that call will get sent to one of our paralegals, and she will find out if there's anything that needs to be done right away. We want that phone call with a surviving spouse. Doesn't have to be the week of the death or even a month later, but we want a phone call scheduled, and that's where my paralegal is going to make sure that that surviving spouse is put on the attorney's calendar. And it's just so that we can make sure that everything is still current, that they understand that they need to update the beneficiary designations, if there's real property, there's some things that need to be done. But also we want to make sure that whoever you've named as your successor trustee, so if you have an individual trust, whether you're married or single, and the trust becomes irrevocable at your death, we need to know, and we need to have a conversation with the successor trustee. So that person that you named needs to know about us. Maybe take a picture of the attorney's card and text it to the person that you named as the successor trustee. If you did a will and not a trust, your person that you named as personal representative, same thing as executor, needs to also know how to get in touch with us. So that when we talk to them, we're going to go, okay, you've been named. Do you still want to do this? Just because you name someone does not mean they actually have to serve in that role, because a lot of time has gone by and maybe things have changed. So they're going to say yes or no. If they say yes, then we're going to go, okay, what are the assets? How are the assets owned? So if that successor trustee or personal representative don't know where your assets are located or how those assets are owned, or if you named a beneficiary, then I'm not going to be able to help them in the beginning. They're going to have to go back out there and find that information, because that is not information that we have. Clients don't keep us up to date with their assets, and I'm not expecting them to. But you really do need to make sure that you have a list of your assets. How are those assets owned, right? Are they jointly owned? Are they individually owned with the beneficiary? So anything that you can name a beneficiary on, you might not see it on the statement, so you might want to write that down on on your own little handout that you keep up with all your assets, saying, pay on death my 2 kids. That is going to save a lot of time when you pass away. We also want to make sure that you're writing out your monthly expenses, your annual expenses, like how those expenses get paid, where's the passwords if you're paying them online, how do we get onto your email. All of that information needs to be available to your successor trustee or the personal representative. I am not saying give that to them today, because you may not die for 10 years and that information could look very different. They just need to know where it's at. Also, we just did a video about death certificate. We can't do anything without a death certificate, and the death certificate information must be correct. So it's very important that you are writing out your full legal name, and that the person that's stepping in knows your primary residence. This is really important. We have a lot of clients who live here and then have a house somewhere else, and maybe they died in that second residence. Well, the kids or the family member cannot put that second residence as your primary residence. Also, we have a lot of times where the person still owns a house, but maybe a kid has decided to move them to an assisted living nearby. The child, not where the client lives. That is not the client's residence, that assisted living. It's still the house. As long as they own the house and the house has not been sold, that is the primary residence of that person. So if a death certificate has to be amended, it is going to cost time, which means we cannot do anything without the correct death certificate. So it is very important that whatever information, your name, your primary residence is out there for that successor trustee or personal representative. Obviously, we're going to tell them this if it comes to it, but it will save a lot of time when they call us if they already know about your assets. They already know how they're titled, because we're going to be able to help them and get this administration process started right away if we know ahead of time that there's only trust assets and no probate assets, or if there's only a house to probate because all the other accounts have beneficiaries. So just be very organized. I know it takes time, but most of my clients and the rest of our clients here as attorneys are retired. And I know that means you're playing a lot, but you can take some time, maybe 30 minutes every week, to get organized. Because this part of you asking someone, it's a huge ask to ask someone to be in charge. And you want that transition to be as smooth as possible. And and you also don't want them paying more attorney's fees than they have to, right? So be organized, make sure they know how to get in touch with us, because we are going to give them guidance. We're going to tell them what their next steps are. First step is to contact us, and then we also will need that death certificate, whether you have a trust or a will. I hope that helps. And then if they have questions, we'll assist, and we're going to make sure that they're doing the correct steps while they're in that administration, whether it's through a trust or a will.